Hey, greetings, everyone. Thank you for attending another segment of the Growth Hour. Tonight, we are doing something a little bit different where we normally have topics, but what we're going to do is have an open floor so anybody can bring any topic that they want to bring. If you have a topic in mind, I ask that you go on Facebook and text me whatever questions or topics that you may want to answer or any topic that you may want to address. In addition to before we get into this actual open floor, I want to make a few housekeeping announcements. First, I want to say that this panel, the Reinvention Center, SEL, SIPI, all other organizations associated with this panel are putting together a program called James B. Jones Jr. Pathway to Peace program, where we are trying to save the youth as well as assist returning citizens. With that being said, within the next couple of months, we will be requesting some form of volunteers to assist us with this, to facilitate this program, and any donations or ideas of any sponsors that may be willing to sponsor that you may know. In addition to that, I want to say that we will be doing some type of outreach program in the near future. Any suggestions, they are all welcome. As always, we're going to do it back to school, but we would try to like to do something before then. Again, any suggestions are welcome. In addition to those announcements, I would like to pass the floor over to Ms. Robinson and have her give us a brief update on what's going on with our brother Dwayne Brooks. So Ms. Robinson.
Thank you, Mr. Jones, and good evening to everyone. The update with Dwayne Brooks is that it is now March 19th, and we are still waiting. We are still in waiting to get a response from the judge from the November 4th evidentiary hearing for the motion that was filed for a new trial. Immediate release, I like to say, claiming that, putting that into words, immediate release and a request for a new trial. At this point, there's been no response, no communication, no word, nothing. We're just kind of sitting in limbo. So just keeping the faith at this moment. Dwayne is in very good, high spirit as he is waiting. Of course, many of you could understand that it is hard to just kind of go through all of the day-to-day things that he has to deal with in his environment. However, he is handling it honestly like a true champ, probably better than me and a lot of other folks that are out here on the outside. So I'm drawing my strength from him. He is strong as ever, and confident that at some point, this has to be heard. It has to be dealt with, and looking forward to that day. In the meantime, Dwayne has been doing a lot of writing, so I don't know if anyone has had the opportunity to join his Facebook page, which is Justice for Dwayne Brooks. And then he has a personal page as well that I'm trying to administer and kind of run and keep up and going. So he's been doing a lot of writing. This is just kind of something to do with his time, a way to get some of his thoughts out, and his writings have been really great. So if you get the opportunity, if you're on Facebook, send a friend request to the Justice for Dwayne Brooks page and check out some of his writings, give him a shout, a holler, comment. It is what has been really kind of keeping him grounded and keeping him connected and keeping his spirits lifted up. And that's all that I have for right now. Back to you, Mr. Jones.
Thank you for that update. It's always important that we advise everybody of what's going on with our brother. We don't want no one to be lost on where the progress is in this case. And we want to always point out how absurd it is of how the system is not moving in a manner that they should be moving in. With that being said, it leads me to something that I wanted to discuss based on what you just said. We spoke before at the we attended the first premiere screening, and we had the topic was not only the first seeing the actual movie, but we also discussed policy changes. And this is one thing that we didn't discuss then that I want to discuss now. Based on what you're telling me, it's leaving my spirit to discuss this. I think that one of the biggest things that needs to be changed is there should be some time restraints put on when a judge or anybody has to respond to motions. Now, they do it for prosecutors, they do it for defense attorneys, but they don't do it for the judges. The judges can hold things for years and nothing happens. I think that there should be some form of policy change that changes that to where they have to, if I file this motion, maximum amount of time you have is 6 months. If you file this motion, maximum amount of time you have is this. If you need more time, then I think it needs to be some type of procedure or mechanism put in place to where they can request more time. Call in all parties of the proceedings and say, hey, this is what the status is. I'm gonna need a little bit more time, and then we go from there. And we set another date, opposed to just saying, hey, I'm gonna get back with you in 2 weeks. And now we working on what, 4 months? Let me see, January, 4 months or somewhere around that. We're going on 4 months. 2 weeks turn into 4 months. But because we are Article 3 official, not all, but because there are some Article 3 officials feel like they are above rules, laws, policies, regulations, and they just I'll respond when I respond. We kind of in a tight place because you don't want to piss them off and then make them just say, hey, I'm not giving it to you. Take it to the appeals court and then drag it out, knowing that you're going to get it, but they're doing it out of emotion. So they make you have to go to the appeal court and go through the same drawn out procedures. So this is why it's not only needed on the district court level, but on the appeals court level as well. But normally, typically, the appeals court is more proficient in getting you a response. Supreme Court is more proficient in getting you a response. It's just the district court. So with that being said, I think that that's a policy change or a rule or something or procedure needs to be implemented that requires them to respond to certain motions in a specific amount of time, opposed to just being just have a free reign, and we can't continue to use that my caseload is overbearing, because if that's the case, either hire some more judges, or pass them over to the magistrate and let's do this reported recommendation, but we need to come up with something. Mr. Hayes, you want to comment on that, sir?
Oh, yes, I do. Lord have mercy. Listen. Aisha, listen. I filed my 2255 back in 99. It took the judge 4.5 years. I had to file a writ of mandamus. This is a motion you file to the appeal court, the higher court, to make the lower court do his job. So what ended up happening, that they said it's going to make the judge angry. I said, I don't care about making the judge angry. He goes home every day to his family. He'll get over it. So after 4.5 year wait, I filed up to the appeal court. It made the judge angry. He dismissed my everything. After he dismissed my everything, the appeal, I filed again back to him. I filed again to the appeal court, because you're supposed to file a motion for what they call COA. For those who don't know what a COA is, it's a certificate of appealability. What you asking with a COA is you saying, hey, Your Honor, you remember that bat you used to bust me upside my head with it? Will you give me that bat so I can hit you upside yours? That's what a COA is. So what's the odds of them granting it? But my judge didn't even entertain the motion. He ignored it to the point where the appeals court just told me, come on up, they'll grant my COA and hear my issues. And even then, it took me almost 2 years, for them to get around and even to just all in all, I did like 7 years on a 2255. The only to get into what Mr. Jones is saying, yes, something there has to be a better system than that. I mean, because they're in a rush to lock you up, but they ain't no rush to let you go, even when they're wrong. So and then after that, that's why I had to write them up. I had to write them up. I mean, it's just then you got it's too much. It's just too much. But I understand that, and that's coupled with most recently. Well, it was different motions that was filed on my behalf, but it took me. No, it didn't take me that long because I had wrote them up. But yeah, it took me about a year and a half before I was actually released after the Trump made they signed that this compassionate release, this bill into First Step Back into law. But one thing I would tell you, Aisha, is this: just remember where we was at a year ago. We had no hope. We went from being hopeless to hopeful to now almost hopeful with a victory. So let's not ever lose sight on that. You know, this goes back to, you know, what Mr. Clifton was saying. God bless him, his wife. How's your wife doing, man? And this goes back to what he was saying yesterday, the last week, regarding he'll get out when it's time. And someone reaffirmed that with the situation I'm going through with, y'all know about my situation, with the inheritance and this and that. And they said, this is why my baby sister said, this is why you was released. You wasn't going to get out when you wanted to get out. You wasn't going to get out a year later. You wasn't going to get out a year before, or a minute or a second before. You got out. God let you out when you were supposed to get out. And that's the reason why you're out. And she had just told me this a few days ago, and I reflected on that statement in that conversation that Mr. Clifton had said to you in the closing of the show last week. But that's basically but getting back to what Mr. Jones said, there has to be a we got time limits on everything. When they pass that AEDPA, they give you 1 year to learn everything about the law. Then you have to file this in so much time. You have to file that in so much time. Then we have time limits and everything. Otherwise than that, they'll procedurally default you. So yeah, there has to be a better way. There has to be a better way. Anybody else have anything they want to chime in on or add to that?
You know, I'm gonna add something to that. We have to, do something to start making them more accountable. We are speaking on it, and as Dr. Carmen does with Court Watch, as far as going and looking at certain things, we might need to start going and sitting in these courtroom hearings and saying, hey, us again, or do something as far as watching the proceedings like this here or evidentiary hearings. Because, you can look on the docket and see when they're going to have an evidentiary hearing, and we can track those and see how long it take from the time that they do it to the time that they give a response. We can track that as well. Even whether we go into court or not, you can still track that by going to the court records. But my point is, we have to come up with something, because this is beginning to be, it ain't beginning to be, it's been this way. It's just that now it's getting more publicized on what they're doing, because like you, Mr. Haynes, I filed a 2255, and it took them over 2 years to respond. And I had to, and the judge, we're waiting on the judge. No, actually, let me go back. I waited almost 2 years for the prosecutor to respond, and the judge was not forcing the prosecutor to respond. And then when I got tired, because I think I told you one time before in the prior show that I sent the message through the prosecutor, through my lawyer, take your time. I'm in no rush, because you know how they try to sweat us out basically by dragging the proceedings. And when they finally come to you and say, well, hey, if you agree to this today, well, then you can get this 5 years or whatever the case may be, and you're tired of sitting in that confined area. So you say, okay, let me take that and go about my business. I was letting them know, hey, take all the time you need, because I know the law is on my side. You know what I'm saying? And I know I was going to do some time. So that's why I felt that, I was saying it that way, but I knew I wasn't going to do all the time that they wanted to give me. So I was saying, hey, I'm already working on the time that I know I'm going to get. So take all the time you need. But you know, it was only after we filed a motion to show cause of why he's not responding, and told the judge if he can't give a justifiable reason for the judge to move forward and give us a ruling, that he came with what they considered a post-trial agreement where, hey, if you withdraw your 2255 and you agree to take these 25 years, we'll drop 27 counts and take your sentence from 115 years to 25 years. So, that is a part of the thing, Aisha, that waiting period and people getting frustrated, getting upset and all that stuff there, and family weighs on family harder than it does us. And I got to a point, and a lot of prisoners don't tell their family a lot of things that's going on in their case because of the constant emotional roller coaster they go through when they're saying, okay, I'm looking forward to this, and we know we got them to the right, but they are not going to do what's right. Even if the law is on our side, sometimes they just say, I'm not going to do what's right. Let the other court tell me that I'm wrong. I've seen that. Yep. And, so it's like they have no regards for you or your rights. Technically, your rights have been taken away once you're convicted. You have no rights, or you have very little rights. Let me say it that way. So they feel like they can just do what they want to do. Any comments?
Yeah, but the sad part about, go ahead, Carlos, you got something you want to say?
I was just going to say I agree, and I just came in, so I want to hear you out first so I can fall into the conversation.
But the sad part about that is it's like an upside down funnel. And when I'm saying that is, okay, when you're at the bottom, you have a bunch of courts, a bunch of judges, different other things here. Then the higher you go up, the more narrow you get. Now you got a 3-judge panel. Now that years ago, now it started in 1989. Before then, whenever you filed the motion into the court, it went to the appellate court, it went to it went to the district court, the appellate court, then the Supreme Court. It was mandated that you, if you didn't like the court's opinion in the district court, you can always anytime file to the appeal court. Okay, after you did the appeal court, if you didn't like it, you went up to the Supreme Court. And it just wasn't a big deal. The Supreme Court heard your case, either they're going to give you the release or they're not going to give you release, and that's what it is. Okay, 1989, George Bush Sr., he signed into law a thing where all Supreme Court don't have to hear all the cases anymore. All right? The people didn't realize what was shortly to come after that. So now your case was heard at the district court level, or you went to trial or whatever, then you went to the appeal court. It was mandated that the appeal court have to hear everything. So they hear appeal court, and then sometimes your case got heard by the Supreme Court, and the other time they didn't get heard by the Supreme Court. But usually the appeal court will claim it out. Okay, fast forward that to 1995 with the AEDPA, with the Anti-Death Penalty Prison Act, Terrorist Act. Okay. When Clinton signed that into law, he's changed the standard now. Now the same standard for the Supreme Court went to the appeal court, because what they are slowly but surely doing is denying the American people their right to redress, to appeal these constitutional errors. That's why I said what I said before. If a judge heard all that through trial, and you filed all these motions saying why these counts should be some certain counts should be dropped, or why your conviction should be overturned, and he still go through with it, you have to go back into court under a 2255, or what they call a habeas corpus, and you only have 1 year to file that, which means you have to learn in 1 year what it took them 8 to 12 years to learn the law. And then once you file that, you have to file it back into that same court. That's all that's been going on. So what happens is the judge denied. So what happens when the judge denied? You appeal up to you ask the court, the appellate court, for permission to appeal it. But you have to send that back to the district court and say, hey, can I have permission from you, the same guy that heard all this and denied it, can I have permission from you to appeal your decision? This is what I meant about the bat. Hey, you remember you just bust my head open with the bat? Can I get that bat back so and bust your head open? What's the odds of that happening? Now when the judge say no, a lot of times the appellate court will side with them and say, well, being that the judge already heard it, he said it's not an appellable issue, we're not going to grant it. So now when you go to the Supreme Court nationwide, only federal Supreme Court nationwide only hears like 2% of all cases. So therefore, the prosecutor can just simply play the game. Well, look, if I can make it past the appellate court, we know the Supreme Court ain't gonna hear it. He's stuck in prison. There's something sickly wrong with that system. And American people need to wake up. And that's why this show is great, and so many other shows like this is great, because it's time for enlightenment. It's time for enlightenment, because slowly but surely, all of our constitutional redress and appeals and different things we have to address the court is being eroded away. And before we know it, it's going to be, again, lock them up and throw away the key. And what this program Dr. Carmen got and Brother Carlos is talking about being a part, that's what needs to happen. If you can hear some of the outrage that goes on in that court, listen, there was a blind man who was a guard. They hired him because he's blind. He wears these special glasses. He couldn't see the glasses. Anyway, the day they charged me, I was on trial for bank robbery. The agent literally brought the man in the court without his glasses, with his glasses on. And he had to hold his hand like as if he was a seeing eye dog. A blind man positively identified me in the court. When they asked him to take his glasses off and held the picture up to right up to him in the box, he couldn't identify nothing. But however, the jury still found me guilty. I mean, this is ridiculous. But what I'm saying is, the show is great. Something has to be done. So come on, people, let's get together and try to make this thing right. Now, Aisha, the only good part about Dwayne is this: it's the hypocrisy of federal court. See, the state can do whatever they want to do. But when you appeal that case up to a federal court, the federal court is going to chastise the state and make the state do their job. Y'all are wrong.
Yeah, and I was going to talk about that, right? How they instead of just go ahead and dealing with the situation, they'll kick it back down to the state. Like, we're not going to fix this. You need to fix this. But all the while time is ticking, right? So while
but they will give him a day. They would tell him you got 90 days to fix this conviction, or and they'll mandate his release. That's one thing when the feds get involved with state cases, they'll tell the state, you got 90 days to fix it. Usually it's 90 days. They don't give them no more. They tell them you got 90 days to fix this or release him.
Well, the thing about that is, we are hoping that it doesn't get to the feds and we get some act right at this level. So that's what we're looking at. And I'm a firm believer of the longer they wait, it's the better sign it is for the person that's waiting. Because if they feel like you ain't got nothing coming, they'll deny you quicker. I want to say this, and then I want to ask Aisha to see if she have any comments. I wanted to touch on what you were saying, Mr. Haynes, when you were saying that when you go up, as far as when you're saying up, you're referring from going from the district court to the appeals court, from the appeals court to the Supreme Court. I want people to understand that it is the district court's job to protect your rights. That's what the judges allegedly, I'm not gonna say allegedly. I say that because of some things I've seen in throughout my years of being incarcerated and help people with law. But I never make an absolute statement when it comes to judges or anybody. But the judges in the courtroom are there to protect the person's right, to make sure their rights are not violated, and to enforce the laws there within the realms of that person's right. Now, that's their duty. That's what their job is. That's what they're there for. That's what their purpose is. Now, once it gets out of that court and it goes to appeals court, what people don't understand is there's a big shift. There's no longer no one trying to protect your rights. Now they're trying to uphold that conviction because they already feel like the lower court, the district court, did everything they were supposed to do to protect your rights. So now they're not looking to protect your rights. They're looking to see if the conviction is one that should be upheld. You know, so a lot of people get that mixed up and they're thinking that, hey, the rights are supposed to be protected when we go all the way up. That's why they're telling you, tell me how your rights were violated. Sixth Amendment, Fifth Amendment, Fourth Amendment. You know, they want to know how your rights were violated because they're supposed to have been protected when they were down there. So understand the higher you go up, the tighter it's like they have your body in a vice grip, and the tighter they tighten that grip on you to a point where it suffocates you or it makes you lose all your air. So you want to try to fight at this level. You want to do as much and put as much on the record at this level because when you go to the appeals court, you don't get to put no more evidence in. They are going to go strictly by what was done in that courtroom. So that's why when you get in front of that district court or in that lower court, you got to give them everything you got. Everything you got. Aisha, you have anything you'd like to say?
Yeah, a few things that I like to say. And before I lose my train of thought on exactly what you're talking about and giving it everything that you have on this level, I guess I have a question kind of around that. I have a lot of questions that are going through my head. Is it true that if you don't raise all of your issues at this level, then you lose your opportunity to be able to raise these issues later?
Yes. Short
No.
answer, yes. Hold
Yes
on.
and no.
Yes, because it depends on if it's a procedural error, a substantial error, or if only way you'll be able to raise it at a later date is if you're saying that your counsel was ineffective and your attorney didn't raise it. He should have raised it. But as far as if you don't raise it in the district court, you can't raise it in the appeals court. Your COA can only be based on what was done in the lower court. And this is why I say put everything on there.
Okay.
Now hold on. Mr. Hayes, go ahead, sir.
No, I was dealing with newly discovered evidence, but go ahead.
Okay, go ahead.
So that's a little bit different.
Because you don't know. If you don't know, you can't raise it. So
Right.
unless when you find out newly discovered evidence, you can bring it in.
But there are time restraints on even that too, right?
It starts when the time you've known or should have known about it. That's how that works.
Okay, but it is a time restraint because you still have, I think it's 1 year to still bring up this newly discovered evidence to any court and try to present their issue out there. If you don't, then they still deem it as being time bar. And I've seen them do that to people. That's why I'm telling you that. That's why I'm saying that. So to answer your question.
And I've kind of experienced that too.
Okay, so to answer your question, yes, if you don't raise all your issues in the lower court, they're not going to let you just bring a new issue up in the higher court.
Okay. My other question around all of this, right? And I hear everyone saying like these things take time, and I get it, right? I'm so grateful to Mr. Clifton. I reflect often on a lot of the comments and just information that he gave to me, that he shared with me, even from the very beginning of, me even starting and joining in with the Reinvention Center. There's some very paramount things that he has said that I've held on to and implemented as I've moved forward. So I'm very grateful to Mr. Clifton for sharing with me, for caring, and also just level setting on a lot of things. He just really puts it into perspective. With that being said, Aisha is who Aisha is, right? And a part of me is just optimistic. It's hopeful. And while I know that this situation with Dwayne is not unique, this happens more than not, but there are some very unique things about his case. There are some very unique happenings and events, and when you put it all together, it's power, it's powerful. And it sets him apart from a lot of other situations. That with that, sometimes I feel like there's a higher target on him. There's a more of a reason to oppose him. Just a real target on his back, and I have not really been able to pinpoint. But the more I see, the more I dive in, the more I try to compare, the more it's just blaringly obvious to me that there's some other play involved with him. But I'm very optimistic, right? And I just, as a person, I'm not the type of person that believes in a no, right? That takes no for an answer. I truly believe that there's a way to do some things. And so in all of this, right, my unsettled feeling is that there is something, right, that can be done. And even when I've spoken with the attorney says, yes, there's something that we could do. And I think Mr. Haynes kind of hinted to a habeas mandamus, a writ mandamus. Even last week, you kind of spoke around filing a motion to show cause. In our, my conversations with Dwayne's attorney, he doesn't feel like, we should be looking to do that at this time. I think he's kind of affirmed that, yes, that is something that can be done, but not something that he's advising that we do. Of course, we don't want to ruffle anyone's feathers, right? And I'm very much on the fence when it comes to that, but submitting. But when, right? Do you really necessarily need to wait 4 years, 5 years, 7 years before you take some sort of action? Because right now, his pacifier, kind of, sort of, to Dwayne was to let him know that he has reviewed other cases that are similar to this. And in his findings, his summation is that it takes sometimes 4-6 months or so for a judge to respond on a case similar to this. So I have real issue with that for a lot of different reasons. I feel like that's a pacifier. I feel like, as the attorney, what are you doing with your time, taking your time to review what you call similar cases? Because I don't feel like there's a lot that's similar in this situation. And like, why are we not making the phone calls to the people to get concrete answers? And then how do you justify that, where this man sat in this courtroom, and this man I'm speaking of is the judge, and said that he asked for post-hearing briefs. He came to that hearing already predetermining what he was going to want, regardless of what took place in that hearing. And what took place in that hearing was epic. And I feel like that it's being downplayed at this point in time. It's a lot of time that's going by, maybe hopefully to allow it to lose some steam, to possibly allow the state to try to build something or fabricate or build a case, because honestly, if I were on that side, that was a real folly. They fumbled the ball in there, and it was not a great representation. So maybe this is a ploy to give them some time to come up with something. I mean, there's so many things, and I know this Cuyahoga County and this system and the great lengths that they will go to. But I'm kind of getting back to, like, when is the time? When is it like too much?
Well, one thing that you may want to request, rather than a writ of mandamus, you could file a mild writ of mandamus. Try a motion for summary judgment. And what the motion for summary judgment is just saying, hey, this guy haven't gotten around to responding. I mean, Your Honor, in light of the motion for summary judgment, we are just requesting that you rule in our favor because of all the evidence that's there. You ain't telling the judge, hey, you punk, hurry up and
Right,
answer
I'm
it.
not trying to call your
No, no, no,
bosses
no. I'm
on you.
not.
I'm not trying to call the higher ups on
Right.
you, but he gave himself this time frame. You know, he wanted post-hearing briefs. He got those, and that was all submitted by December 29th. And he sat in that courtroom, set that timeline out, that December 29th, he wanted to have all of the post-hearing briefs. It would take him possibly 2 weeks or so to review those post-hearing briefs, and then he would be ready to make his ruling after he reviewed them, which should take him no more than about 2 weeks or so. So that is where that time frame came from, right? And then in just speaking with people, it's like, well, this is post conviction. It's not really a priority. I feel like you, Mr. Jones, like we do
That's
have to do
ridiculous.
something about just that being the answer and that being okay, because these post conviction people are people who have served way too much time for something that, you know, should have been addressed a long time ago. That becomes a priority. If I'm sitting in my profession and, you know, I'm the professional. I know about how long it's going to take me to deliver something. I have deliverables to give to you as my client. I know what it's going to take me to get the information. I know the obstacles that I'm going to run into. I know, you know, and I can give you a general idea. So, you know, okay, this should take me, I should have estimates for you 2 weeks. It might take me 30 days. Okay, we're dealing with a hard market somewhere. So that's going to take a little bit longer, or I got to go through a third party. That might take me a little bit. So, you know, 60 days. I'm thinking that. So I'm thinking that is what the judge was saying at the time that he was saying. It is hard for me to believe that this man is just sitting there and bold-faced lying if I'm to believe that this usually takes 4 to 6 months, then he should know that better than anyone. But it's just mind-boggling that it's this much time and that there is no word, not even a status update, not even a come to the table meeting, like, you know, whatever the case may be. I got a large caseload, or I haven't had the time, or I have a death in my family, or I'm dealing with such and such, and this is why we haven't come to an end result. But when is it time to be able to come to the table or just ask for a status, an update? How long is too long?
Like I said, I
Go
would
ahead. Go ahead.
I would request for a summary judgment regarding that. Just bring it to the lawyer's attention. You think we could file for a motion for summary judgment, just to, you know, kind of like nudge the judge on, because what happened with me to keep them from forgetting about me. That's why I was explaining to you, like as cases came out regarding like pretty much what happened with them releasing all these people from Cuyahoga County. As people was getting out on the second chance act, or this first step act, he would always he would attach the case there, and he would do a supplemental brief, and just letting the judge know, you should let my client go because such and such and such. See, this case. And let's just keep just to kind of keep the it's nudging the judge, but it's not really pushing them off. It's a supplemental brief, and you're just keeping them abreast of what's happening overall in all the courts and stuff like that. Or something that then somebody else get released. Even if it's even in another state, this happens similar to Dwayne, and file the supplemental briefs for every time that happened, and people's getting left and right. I was getting brief after brief after brief, and eventually I went home.
Hey, Kevin, your point, right, is it brings in like, why do we have to tiptoe around judges when we're submitting? Like this at some point we gotta deal
They're
with
here to protect our rights.
Yeah, but we shouldn't have to deal. We shouldn't have
And
to
we gotta
tiptoe.
tiptoe.
And like they used to always tell me, well, you don't want to piss the judge off. You don't want to upset the judge. Like, why should that even be a discussion? You know what I'm saying? Like in professionalism, like you're going to be professional or you're not, right? So the fact that we are afraid that we're going to trigger their reaction emotionally is an issue in itself. And in the lifetime appointments of some of these judges, like we got to deal with these emotions and tiptoe around these people's, like that in itself is a discussion. Like that's crazy.
Oh, let me tell you the major reason with all y'all. Let me tell you the major reason why this is a problem. Okay. When I wrote my judge up, I did a background check. When I did a background check, I see he was a prosecutor in the Eastern District of New York for over 17 years before they even appointed him a judge. George Bush Sr. appointed him a judge. All right. He used to prosecute cases with a woman with a magistrate judge. But they used to prosecute. And then the old prosecutor that still is still prosecutes cases. So here's what I'm saying, right? He became a judge from a prosecutor. The prosecutor lady that they was prosecuting cases with, she became a magistrate judge, and then their buddy still was the head prosecutor of the district I was in. All right. Here's the problem with that. It's called nepotism. There's no way that I am going to stand before you. In the case I used against him, I know you appreciate it, the appeal court had overturned it because they withheld some evidence from a guy. So I said, hey, pretty much, y'all remember when y'all got together and did this? So I know he didn't appreciate it, but I didn't appreciate being a judge. So at this time, I had a rack of years in, almost 20. What the hell I give about? You getting upset. I'm living hell. You go home to your family every day. Get mad at me. Scratch your and get glad. Anyway, nevertheless, that's what I did. But that has to change. And I told my judge friends this. I said, look, what needs to change is if a judge is going to become a prosecutor, if the prosecutor is going to become a judge, he should have to move from the district court that he's in to another district court.
Because of the relationships he has.
Right. The movie they did, what Jay-Z and them did, the movie about the big drug guy, I forgot his name. They did the movie. I didn't see the movie, but I know the judge.
Oh,
There's a
Kaiser Sosa.
No, this was the one, the black guy where he shoot Frank Matthews, Lucas, or what's
Frank, that's my cousin.
Frank Lucas. Okay, Frank Lucas. Okay. Not Matthews, Frank Lucas.
Frank Matthews is from Durham. Frank Lucas is from Seven Spring.
Okay. Frank
We're
Lucas.
talking about American Gangster.
Right, but in that movie, there was a black special prosecutor. I don't know if they show him in the movie. I never watched the movie. But there was a black special prosecutor who really nailed that case. I don't know if they show him in the movie, but it wasn't all that Russell Crowe stuff. That black special prosecutor name was Sterling Johnson. And when they elected Sterling Johnson, and that's the Southern District of New York, that's Manhattan, and that covers the Bronx and all that. So that's the southern part of New York. They call that Southern District of New York. When Sterling Johnson became a judge, they moved Sterling Johnson from the Southern District of New York to the Eastern District of New York. And if you want, God, we all wish he would have stayed where he was at. Ooh, Lord have mercy. He was just a prosecutor in a black robe. But however, that's what needs to happen. If you are prosecuting an ISIPS Long Island, then you need to come into Brooklyn. If you're prosecuting in Brooklyn and you want to be a judge, you might want to go to Manhattan or to Yonkers or somewhere else. But you should not be able to continue to practice law or be a judge in that same district court. This is the beginning of somewhat balancing out the field of play. And 9 times out of 10, Aisha, if you do a background check on that prosecutor and that judge, they probably been prosecuted cases together.
Conflict of interest.
But they don't deem it that because they're judges. It is madness. But this is what a lot of people don't know, and this has got to change.
Okay, so we read the comment. It says, Carlos, theory versus reality. Hold on one second. I got to get back to it. It says theory versus reality. Not supposed to have to tiptoe, not designed to work that way. But when fighting for your freedom, make the decision that give you the best chance to win. You are correct. But ask yourself, if the attitude of aggression is what you want to use while you are still incarcerated.
Oh yeah, listen, they preaching to the choir. This I'm somebody who went to trial. I know how to proceed. I said we shouldn't have to. But
that's what they're saying. They're saying, I agree, and I think they agree, that the person made a comment, agree that you shouldn't have to do a lot of things. Shouldn't.
Yeah, but we have to, but we do.
But we do. We shouldn't have to do a lot of things. Let me touch on a few things because I've been sitting back listening. First, I want to remind everybody, especially you, Aisha, it's a lot of stakes. It's high stakes involved in this decision. That don't mean he should take all the time he needs. But I just want to remind you that on his decision lies if Dwayne gets free, if Dwayne stays in prison, if there's going to be a compensation after Dwayne is free, amongst other things. So I would think a person in that position going to want to dot their I's and cross their T's, because we got to keep in mind that the state can still appeal and say, no, I don't agree with his decision as well. Go ahead.
Right. I agree. So let me ask you then, was that just blasphemy that he just sat there and gave himself this timeline for this ruling to come back?
I want to say that I'm 100% against what he did, and I want to say that he loses the confidence of the people to sit in front of the people and say, hey, I'm going to do something in 2 weeks. And you know that you're not going to get that accomplished in 2 weeks. However, we're not in his mind. I don't feel that he could have got it accomplished in 2 weeks based on the magnitude of the case and the stakes that's involved. Let me say that first. But he may come back and say, well, hey, I'm a trained professional. I've been doing this for so many years. So I felt like I could have got it done in 2 weeks. Okay, now, do I feel like he could have did it? Again, no, I don't think he could. I don't think he could have made a decision or wanted to make a decision within 2 weeks, because you asked for briefs, which is going to prolong the time period for you to first get the briefs, second to read the briefs, third to research, break down, and all that stuff.
His timeline of 2 weeks was after the post-hearing briefs. So
that means he's going to set aside all other cases and just work on Dwayne Brooks' case. That's what he's saying if he gave himself a 2 week period.
From the time that the briefs it was going to take him 2 weeks to read the briefs and come back with his ruling. Okay, which put us in the mindset that, you know what, because had you been there, had you sat through that hearing, his ruling could have been made at that hearing.
I agree. And I want to say this, not cutting you short, because we want to answer all your questions. I agree. But it's as Carlos Parks says and Mr. Hayes says, sometimes they say, hey, you better fix this before I give a ruling. And you might want to fix this before I give a ruling. So that's a subtle warning that, hey, we got to do what we got to do. What I would do,
and I 1,000% agree with that, right? Because the reality of the matter is the motions were filed. The between the motions and the post-hearing briefs, on both sides, really, there's not much different.
No.
So Your Honor had all of this information and everything that we were claiming and all of the supporting evidence from October 12th of 2021. October 12th of 2021 is when the motions were filed. So that's in their records, okay? They then pushed it back. If you remember, there were several delays, but all of this is in your records. So now we get to November 4th of 2022, where we're now having the evidentiary hearing. And now at the evidentiary hearing, the state brings their witness, which is former
evidence.
prosecutor,
Which is evidence.
former
Okay, go ahead.
prosecutor, but they already had an affidavit from him, but now he's
Which
here.
is another form of evidence. But
He
go ahead.
gets on stand, he testifies, and he says, yeah, we always withheld evidence. That's what we did. Oh, okay. So now, but the judge had already predetermined before that November 4th hearing that he was going to ask for post-hearing briefs. So you have that, all of this is in front of you. So it was no question in our minds that, okay, well, he's going to ask for these post-hearing briefs. He's going to take an additional 2 weeks. That's procedural. If it took a month, if it took, a month and a half, but all this time and nothing. And yes, the stakes are very high. And yes, you want to give them time to make sure before I come with this ruling, y'all better get yourselves together. So that's where we are right now.
But Mr. Jones answered that. He was saying he's probably telling him you might want to fix this before I make a ruling, because the rule because this case, you don't fully understand the magnitude of this case. We talking about from not for you. We talking about from 1963 to now.
It's
Okay,
not
hold on,
not just
Aisha.
Dwayne. It's about a lot of other people.
Okay, hold on, Aisha. We have somebody that want to comment. They haven't said anything, and I'd like to hear what they have to say. I'm sure everybody does. Sasha, Manti, good evening.
Everyone. There's a couple of things I want to say, and I'm kind of skirting into it because I'm kind of working backwards. This is the deeper piece, right? This is the biggest issue. And then I'm kind of working it backwards to where it commenced from. Because what both you and Mr. Haynes mentioned was a very real process where they say, hey, they're buddy, their relationships go deep from back in the day when they went to school to the relationships that they have to see themselves daily in. So they have made their relationship. They've gone to each other's quinceañera and whatever family events. They know each other, and so that process is very real, and they're very protective of each other, right? So sometimes, yes, there is a time where they say, "Hey, this came across my desk, and I need you to fix what you got to fix, so we can fix this all together." And sometimes it's an issue of emotion, like Mr. Haynes mentioned, of putting a nudge, a little push. And I want to say mainly that the sword, the pen is mightier than the sword, because the eloquence that is placed on emotion that Mr. Haynes had just mentioned would respectfully, and I know Carlos don't like how that sounds, but reasonably, because that's why I said respectfully, I mean with reason, placed in a position to nudge and to push forward, and it be recorded, because that's that piece, that if you do that type of motion, it's a recording, an evidentiary piece of putting people in place to do what they're supposed to do, right? And I want to go back to saying that the sword of your words, of being able to write, is so important. And that's a piece that people don't really realize. Yes, you need to know the processes, but what you put in that motion, when it specifically entangles the responsibility of that seat to move a certain way, and you're moving them in that way, you have to have the level of education and eloquence to articulate it. And that is something that they've taken away from the school education level, when they used to teach civics, when they used to pay attention to government and making sure that the youth knew what that meant and what voting meant, and all that concept was taken out of the school for the continuing pipeline to prison relationships and how it's very hard to defend oneself if you are not knowledgeable to be able to do that. And then you have a bunch of professionals that don't reflect the demographic that you're coming from and comprehend fully what you're dealing with when it comes to cognitive dissonance and the constitute or the racist construct that has been created to do that. So this, I say this in a way that we see the bigger picture, but the symptomatic circumstances come from a deeper construct to make this happen. So that's all I say for that.
All right, thank you. I wanted to also say that Aisha, I heard you say, and we all say that the judges, why we tiptoeing around a judge that's supposed to protect our rights. Once you're convicted, you don't have no rights. That's the way they see it. You know, your rights are limited. I'm not going to say you don't have absolutely no rights. Your rights are limited at that point there. And what's, so it's funny, but it's true. They say like we
No,
don't
it's
have
not,
no
but
rights.
that's the truth. I
So
chuckle
we're
because
saying,
that
hey,
is what
protect
it
the
is. He
rights. I
doesn't have
protect
any rights.
your rights were protected at the trial. That's what he's saying. Your rights were
Mhm.
protected here. You see what I'm saying? So they kind of found
Mhm.
down on saying that there was an error committed during the process, because that's admitting that one of the people that's involved, and we spoke on friends, co-workers, family. One of the people that's involved was wrong. So that's a big step. Myself, I laugh when I tell you this, but I didn't tiptoe. I didn't tiptoe because I was facing the rest of my life in prison. So if I lost, I'm going to get the rest of my life in prison. So why should I tiptoe? I had a marshal tell me one time, hey, you got to be careful, man, because that's the same judge that's going to sentence you. You don't want to piss off. And I said, hey, you got to remember, the least I'm going to get is 1,380 months. So I'm never getting out of prison. So I got to fight. And he said, well, that makes sense. But again, we are taught and we are told and we are influenced to tiptoe. And as I've learned, the S words, we should have to do that. But, just like we say, we put on suits to go to court, they look good and all that stuff there. For what? For them to give us a hefty sentence? He said, in your court, in court, your rights are what you are fighting for. The prosecutor, let me go back to this because somebody commented on this here. The prosecuting argument is the trajectory to the fact. Hold on. The prosecuting argument is the trajectory to that fact. So the argument is not correctly placed all the time. Okay, now I want to.
Is that clear? Is that clear? Did everybody get that? Because I know sometimes I type too quickly. Did everyone understand what I was trying to say?
Say it, just say it.
I apologize. I was saying, and it goes to what everybody's saying here. When you're in court, when they say you don't, they don't have rights, that's what's up to play in court. Your rights. Your rights is what's up to play. That's what you're fighting for. It's not necessarily the case. The case is the trajectory to persuade one that you're arguing about, let's say, stealing something or killing something or hurting someone or whatever. That is a trajectory thought. That is what they have to prove to say that they have the right to take away your rights because you don't deserve them. And so if that is not paid attention to in the fight, then you lose the case altogether. And that's what lawyers have a tendency to do because they're going by the playbook of fighting the trajectory and not fighting the actual fight, which is the preservation of your rights.
I agree. Very well put. Let me add this on. This is the last thing I wanted to speak on. It was brought up by a lot of the panelists. We spoke on lifetime appointments. I think that lifetime appointments needs to change. I think that there should be a certain amount of cases restricted, saying, okay, if you get this many cases overturned, I think there should be some punishment. There should be some consequences for you as a judge. If you get 3 cases overturned, then we're going to get you in front of a board because you're not doing what you're supposed to be doing. Go ahead, I'm listening.
That's never going to happen because I give you class example. My judge, he's sitting up there with the appeal panel. Because he was a visiting judge at the Second Circuit Appellate Court. So by the time I got up there, the decks were stacked. So that's why when I wrote him up and he was the chief judge, I wrote the chief judge of the Appellate Court up. I'm taking, it's like just like you, Mr. Jones, I had nothing else to do. I only had like forever in a day. So who would I care about whether you happy or sad? And when I did that, it opened up the world of wonder for me. But what I'm saying is, getting to what you're saying, what you're saying is right. But it's corrupt from the top, well, minus the Supreme Court to a degree. But when you deal with that appeal court and that district court, because if you read some of these cases, they have 2 appeal courts and they have a visiting judge from the district court on them cases that's making different rulings on them. So they all buddies. How do you win? How do you win? That's why you have to.
Okay, I won because I won my case because the rules were already established. The appeals court ruled on some cases prior to my case, and I was applying the cases that they ruled on to my case. Now, I feel that I'm not saying there's no corruption in no other higher level than the district court. I'm not saying that. But what I'm saying, if they're held accountable, then what needs to happen is there need to be some consequences behind their action. If you get 3, like for example, Talladega County, you got how many cases that's been overturned saying it was wrongfully convicted? If that would have happened 3 times and the judge that was doing that would have been held accountable and there been some consequences professionally and personally, then it wouldn't have continued to happen. So that's why I feel that we need to get to a point where we are, hold on one second, we are holding them accountable. Ms. J. Love, I see your hand up, Sasha, in my team. Ms. J. Love said, a lawyer told me that courts are not concerned whether you are innocent or not. That's not the goal of the prosecutor. The only goal is if the person had a fair trial. That's it. That's all. They do not care. They just follow the process.
I want to add to that statement too, just now, what that person just said. Not only do they want to do that, they want to pack it in with as many charges that will stick for that process to go through. So that actually exists also. The persecutor will make his case. His job is to make as many cases in his career that's going to stick. And how many charges, when you get into a situation, they don't just give you one charge. They see what's going to, how many of these things that is going to go through, because the opposition is not going to be able to argue to take them off or to come off or to be able to do their case. And so the more they stick, the more they're higher in their career, the higher the pay, the higher the recognition. And that in itself can be an addicting situation to be in.
Let me ask you this. So how do they get so many cases to stick?
Easy, very easy. The practice of not doing your due diligence is a great way of doing that. It's the lazy responsibility that people have when doing their processes. They're being lazy. And it's not to insult anyone. It's not to say that there are not good lawyers there, they're not good judges out there doing their job. That's not what I'm saying whatsoever.
But it's a whole lot that's not good.
But there is a custom. There is a custom to the business area where it has the level of professionalism has lowered, and that lowering has been accepted as the general acceptance of how everything is going to flow. And that is in accordance to how they lowered the public's ability to address things correctly. Because it's our responsibility as the people to know what we have in equity, to know what we have in property, to know what we have in our name, to protect that. And if that has been lowered through education, through not nutritional issues, through breaking up families, through all these different symptoms, then yes, they can create a level that they say, well, I'm servicing you enough. That's very similar to equal, but yet separate, but yet equal. Remember that the schools were great in one area, the schools were bad in the other, but you still had a school, right? Very similar, very apropos to racist construct. And that racism is not only, is based on indigenous people, it's based on a lower class, it's based on status and that whole piece. And I
Let me
forgot
say-
what I was originally going to say, but that's it.
Okay, so let me say
They
this, let
get
me
those
add this
cases
on
to
that.
stick by withholding evidence. They get those cases to stick by fabricating, bringing fake witnesses, false identifications. They get those cases
And the
to
pressure
stick
is real.
by.
And the pressure is real to do that. It's a pressure that is real to do those things. Sometimes they get recognized to do those. Oh, you know, I didn't do this paper on time. I didn't send this in on, just, wax over it and just stamp it. It's okay. Back stamp it, backdate it. Do me a favor. And sometimes they say, oh, well, John is the person that you want to get to do that, because they'll do that for you for the case, and you'll get your stuff through. You don't have to worry about getting in trouble by your higher ups. Again, it's a custom of business that lowers the level of service, because courts are supposed to be in your service. That is a reality that is not right. So yes, that's what they do. And then there are other aspects where things are done correctly. And you would hope that you go into one of those courts to do those things. But what's so funny about that too is that when things are done correctly, those same people get disappear. They get taken out, like Mr. Haynes said, to another area. They're not team players into the cognitive dissidence of people and of a profession, because cognitive dissonance does not stop at the people. It is a part of a profession affecting the people in the professional atmospheres that they are in. Very much similar to police officers, where, quote unquote, you have a good cop, but that good cop is not allowed to police in his neighborhood where the relationships exist. There is a lot of duality here that is unbalanced. And we hope that in the work we do, we create the cognitive resonance that's needed to raise up the level of accountability and responsibility for a person's actions on all levels.
Okay, Aisha, I would like for you to finish reading that list to add on to what Sasha's saying.
They get those cases to stick by falsifying witnesses, by coercing people into taking plea deals, scaring them. They scare tactics. They get these cases to stick by working backroom deals with public defenders. They get these cases to stick, again, I'll say, withholding evidence, not producing information, and it's not a suppression of information, because in order to have something suppressed, you first must bring it forward and have it approved to be suppressed. So it's just hiding information. They get these cases to stick by just outright, as the prosecutor testified, not turning information over. They get these cases to stick by just removing any truth, and just truly building lies. They get these cases to stick by using other cases. They use these controlling cases where they've done something illegal previously, and now they've gotten it through in one court, and now they can use it to prosecute and manipulate other people. They get these cases to stick by not allowing people in the courtrooms, not allowing family members in the courtrooms to witness what's actually taking place. They get these cases to stick by maliciously prosecuting. It's malicious. It's malicious. It's malicious. It's malicious. They get these cases to stick because a lot of times the people just don't know any better.
Let me say
And,
two-
and
I'm sorry, go ahead. Go
it's
ahead.
awful.
Okay, let me say two
Go ahead.
things. First thing I want to say is, it definitely is is what you're saying as far as intimidation, scare tactics, coercion, and stuff like that. Two things I'm going to say. First thing I'm going to say is, in the feds, it's a 98% conviction rate. 98% conviction rate.
These things are unheard of.
I'm gonna tell you why though.
Like this,
I'm gonna tell you
unheard
why.
of.
They're not talking about people that's going to trial. They're talking about people that's plead guilty. Now, I'm gonna explain to you why it's scare tactic and it's intimidation in the feds. Because I was charged with a 35 count indictment and I went to trial. They offered me 1 count of conspiracy and 1 gun. 1 gun. Okay, so now the conspiracy, they allow them to bring in what they call relevant conduct. So when I got sentenced, I get sentenced to all the relevant conduct. Relevant conduct. Let me repeat that word, relevant conduct. So that means that's anything that's relevant to the 1 count that conspiracy, they get to sentence me to. So that means that if I pled guilty to that 1 count of conspiracy and that 1 gun, they can sentence me as if they found me guilty of all 35 counts, because all 35 counts are relevant to that 1 count of conspiracy. So if you go to trial, you got to beat every count. You can't lose on 1 count, because then you're going to get sentenced as if you lost on all counts. In addition to that, they got something called acquitted conduct. Let's say I got 35 counts and the jury found me not guilty of 34 and found me guilty of 1. I still get sentenced to a sentence as if I was found guilty of all 35 counts. So that's the intimidation factor, where you either got to beat them all or you're going to get sentenced to all. So now I'm going to take the plea that they're offering, not me, myself personally, but people are going to take the plea they're offering to get that relevant conduct, the acquitted conduct, and all that stuff off of their head and be able to see some day of life. Now, the second thing I wanted to say to you is this. When I got in trouble one time before in Louisiana, state of Louisiana, people might know, might not know, Louisiana has no counties. They have parishes, because Louisiana under French law, they're not under English law. So the laws are completely different over there. So, I want to tell you that I went to jail for shooting some people. And I sat in jail for a while, and they came to me, and this is part of the reason that made me get on my quest to learn the law, because they kept coming to me, offer me please, offer me please, offer me please. Eventually, I took a 5-year deal. They sentenced me to, I think it was 17 months or 2 years or something like that there. 2 years, give me 2 years. Credit for time served. Years after months of sitting in the jail, before I get shipped to prison, I see the guy walking down the hall that they say I shot. One of the guys walking down the hall that I say I shot, because there's multiple people shot. And he says to me, he sees me, he runs up to me, he hugs me, said, "Man, what's up, man? Where you been at? I was wondering what happened to you. Why are you in jail?" That's what he asked me. "Why are you in jail?" And I said, "Man, I'm in jail for shooting you. What do you mean why I'm in jail?" And he told me, "Man, I told them people you ain't shoot me." So immediately I didn't plead guilty. I'm sentenced now and everything. So immediately I go to the phone and call my lawyer and say, "Man, why did you have me plead guilty to this when I just bumped to this guy and this guy said he told the police that I didn't do it?" That lawyer told me, "I didn't tell you to plead guilty. You the one wanted to plead guilty." So from that point on, I said I will not be in that position again. I will not be in that position again. So, in all actuality, they never had nothing. And we done paid all this money for these high-priced lawyers in Louisiana. We're flying lawyers from Miami all the way up to Louisiana to get the representatives. And they don't have no evidence. And they came with something because they're telling us, "Hey, you're facing 99 years in in prison. And in Louisiana, back then, it is 80, 89, 90, Louisiana, Mississippi, Texas, Alabama, it was hard labor. You go out there and you work in the fields, you got the horse following you, the man on the horse with the gun, and you got your shovel and you do whatever you're doing. So that ain't what I wanted to do. So I took the deal and then found out later on that, hey, it was a bad decision. But my point is, this happens all the time. And now, because of technology advancing, we're getting able to have meetings and educate people the way we're educating people. Because of cameras, we're getting to record things that's always been happening and bringing it to the light now. So we just have to continue to be who we are and continue to pass the word, educate people on some of our personal experiences, and hope that they don't have to deal with it. But yes, it is intimidation, but they plead guilty. They plead guilty. Not enough people going to trial. Because if they had to prepare cases if they arrested 1,000 people and they had to prepare cases for 999 of them, a whole lot of people going home. Any comments?
Yeah, what you're saying is actual and factual, but the whole thing about it is no one want to be the first one to sacrifice being put their head on the chopping block. And therefore, that's the problem. It's kind of like what they used to do back, I alluded to it last week, about slavery. What they did with the slave, where they cut the pregnant woman's stomach open and everybody just walk lockstep. Or they'd throw one slave overboard and everybody would walk lockstep. Or they'd cut a foot off or arm off and show the master show his cruelty to one, and everybody would walk lockstep. We have to change our mindset and just fight. It should be like a boxing match. Fighters coming in and they brawl it out. But one thing about a good fighter, whether you beat him or not, there's an air of respect there. And you just can't keep fighting and fighting and fighting, as Mr. Jones already alluded to. If enough people went to trial, there would be a whole lot of people going home because they wouldn't be able to prosecute all them cases. And them cases cost a lot.
I'm not talking about from the economical standpoint. I'm saying for the human error standpoint. That means they would have to actually get out there and put some work in and actually investigate some people and come up with some things. My advice today is this here to anybody that's thinking about going out there and committing some crime. Don't get involved with that because the system is completely different from the way it is. We're not fighting because today is self-preservation. People going to court and they saying, hey, I ain't going to do these 10 years. That was mine. I really wasn't making no money. It was Kevin's on. So man, Kevin gonna have to deal with that. So why put yourself in something the deck is stacked from the start in the first place? Don't misunderstand me. My advice again would be not even get involved in, because back when we were going to court, you had more people, not saying everybody, that would stand up and say, hey, we're going to trial, or I'm not going to tell on my man, or we even did, if it's 4 of us in the car, we all ain't going to jail, one of us going to take the rap, and whatever the case may be. Today, it ain't like that no more. It ain't like that. So, to be in the world trying to commit crime today on a constant basis, it's kind of crazy. On a constant basis, trying to make a life out of a career out of it, it's crazy. I wouldn't encourage that to anybody. So, that's why, they get away with it, because today they're telling nobody wants to do no time. Everybody's pleading guilty and so forth. Go ahead, Sasha.
I'm going to mention on the tail of what you just said, and it's so important to understand. Yes, it is definitely a different culture from when we were, I'm still younger than some of y'all. No, I'm kidding. But from back in the day to now, there's definitely a different culture when it comes to the youth and how they're being affected. But again, it tips back to the pipelines of prisons. They're getting felonies 16, 15, 14 years old. They're getting all this stuff early. and they're being programmed in their behavior, and they're seeing there is no other way out in circumstances, because once you get that felony, you don't have a career, or you are having a very hard time having one, or having somebody support you. There was a comedian that made a joke, and I'm not going to say it right because I'm not a comedian. I may say funny things sometimes, but I'm not a comedian. But they particularly said that if it's a Black person getting in trouble, calling a Black person, what you did, how you get there, what you do, you gonna have to find your way out. But then if it's a Caucasian person or a person of an upper status or upper economics positioning, they'll be like, oh, he didn't do anything. I'm coming right down and I'm going to go get him out. And don't you dare touch him. I'm calling the lawyers, or I'm calling representative to make sure they're out. And again, it speaks to what we spoke about prior, Mr. Haynes mentioned before. When you have affluence and influence, your cases go a long way differently, very, very differently. So I say this all to say that right now we're working with a developer, right? And I want to be clear. All these cases that go on that are unlawful, that are creating precedents to behave unlawfully in court, to receive unlawful judgments, they're creating numbers. They're creating statistics and reasoning as to what Aisha was saying earlier, to use these cases as a precedent to jail more people, right? So there's a statistics out there. And we're working right now with a developer to to deal with some of these algorithm biases that creates the results that say, okay, this percentage of this community does this all the time because look at their caseload, or look at this, or look at that. And so we're looking at that to be one of those solutions to addressing these algorithm biases that they create for the purpose of bad judgments, for the purpose of bad health, and reasons to create food deserts and circumstances that would support more recidivism. So hopefully I put an input in there that's of positivity and recognizing these issues are going to continue. And unfortunately, the children are becoming weaker in facing it instead of stronger. And we at this age, knowing both environments, being from back then and being in it now, that we can create some real solutions to addressing them. And I think Mr. Brooks' case is definitely one that creates this precedent to bring that forward also.
Yeah, I don't really know of a positive way to deal with like absolute corruption. I don't know how to tiptoe around these types of things. I don't know. I was just quickly looking at the comments, and J Love, my heart, you just have my whole heart. But she mentioned in her comment about in Detroit, this ring of snitches. Like, this is the levels and the lengths that these people will go to solidify convictions. They have informants working for them, a ring of them. This is their profession. And so they can call on them at any given time to come and sit and testify to whatever it is that they want them to testify to. Like, how do you come up against these types of things? I really don't know of a positive way to just, come up against that type of an absolute corruption. And that's on top of the deck being stacked in their favor in every other way, right? From classism to colorism to just every other way. And moving further and throughout this, it's just so mind-boggling how at no point at any level, like, do any of these officials, are they willing to really make a difference, really just do the right thing. There's never a wrong time to do a right thing. And it would seem to me, especially like in Dwayne's case, you've got a brand new judge sitting here. He has the opportunity to kind of set some things right. And I understand that the stakes are super, super high. I know that there's a lot to lose, but it's just high time to start doing the right thing. The things going on in Cuyahoga County, it's the right time to just do a right thing. But with that, it's like you have everything that judge, this current judge right now has everything that he needs to just make it right and kind of blame it on that was under, those authorities, those officials. We're moving into a new way, and he can come across as kind of blameless or not have to take a lot of that blame. I mean, I think when I did the first rally, I think was August of last year, the first awareness campaign, I'll call it, might have been August of last year. We were at the Cuyahoga County was at like 33, maybe 34 wrongful convictions, people who had came back and were deemed wrongfully convicted, right? Because there is that difference. There's people who have actually been deemed wrongfully convicted. There's exonerees, and there are people like Dwayne who are just sitting there. There are more people like Dwayne just sitting there. But at that point, it was like 33, 34 people had already come through the courts. So now here we are a year later, and there are about 20 more because it's sitting at about 50 something. I don't even know what the number is right now exactly, but it's over 50. So yeah, the courts are backed up. Yeah, I understand that there's a lot going on top of everything that's brand new coming in and coming through, because those streets, it's really sad. There's literally zero for anyone to do. That's a whole nother issue. It's very underserved. Children have no outlets. It's really sad. But again, it's just time. It's just time to. If they gave us an opportunity, I bet you we could go in there and clear them books.
Motivation. But I definitely feel that we could. I also want to say that J Love made a comment, which is true. Often when we hear wrongful convictions, we're thinking about the felony convictions. But what about the misdemeanor wrongful convictions that are swept under the rug because the sentences are so light? What one thing that Dr. Carmen Johnson is fighting for is to have her name clear. It means so much to her for her to have her name cleared, because it shackles you, it limits you, it puts restrictions on what you can do in the world. You hear it, but until you actually see it, you don't really too much pay it no mind. But that conviction to stop you from getting a housing, to stop you from getting jobs, as we know, but definitely housing, that's something that everybody needs to have. And where I live at or what I'm doing shouldn't play a part in, what I did 20 years ago shouldn't play a part in where I live at today, but it does. It does, and, so again, I would just say that it's a time for change. It's a need and a time for change. And that's what,
Time.
that's what we were saying at the First Step premiere. It's time to change some of these policies and these things like this here, and please, understand that, yes, we've been in, but we're home now. and we have served our time and we're doing constructive things. So we're not crying or whining or none of that. There, we're standing up and we're bringing to you exactly what it is that you are not paying attention to. It's a time for change. There's a need for change. I strike on that. I stay on that. Anybody want to give any closing remarks or anything before we wrap the show up tonight?
Yeah, I want to address the situation regarding the rat stuff. J Love mentioned the team of rats, and there's a rats in Dwayne case, there's rats in your case. I mean, the court is infested already. There are rats everywhere. But this is my thing, right? The reason why it's like that is because when you get back into the schooling, you have to get into the essence of American history. To be a rat, to work with the government, that is not the American way. When you get into the history of the making of this country was never meant to be an American country. This country, these people came over here from England to establish a British colony. Not we hear this sunshine, cushy, mushy story. Oh, they got tired of King George and they came over here because there's a pressing lamb of religion and their rights. No, these people been over here over 100 years to establish an English colony. What happened was they ran up a debt. Upon running up this debt, they didn't want to pay it. So they took the country from them, period. All right? One of the guys who realized what they was doing wrong when they took this country from England was a guy by the name of Benedict Arnold. When we came up in school, we all learned about Benedict Arnold. Then Benedict Arnold was a traitor, and or better yet, named a rat, a snitch, a tattletale, a parakeet. And when you know too, Mr. Jones, Mr. Clifton, you too, Aisha, if anybody called you a Benedict Arnold in class, there was a fight when you got outside at 3 o'clock. Y'all can laugh, but y'all know I ain't lying. If someone jokingly called you a Benedict Arnold, when they got outside, you had to fight and you fought, win, lose, or draw, because you had to prove that you wasn't a Benedict Arnold. And even if the guy apologized, you still had to fight him because your honor and your integrity was on the line. Because even at that very young age of 5, 6, and 7, you understood what portrayal, what ratting, and what snitching was. And you didn't want to do that because nobody wanted to be a Benedict Arnold. But they took all that out of the textbooks now.
Okay.
And this is why we see the pandemic the way we see it.
Okay. J Love gave a comment, and I'm gonna read this, and then we're gonna wrap this up because time restraints. She says, "Let's pay close attention to Tuesday when Trump supposedly get arrested. We will see the other side of the justice system. Get ready." That's her comments. Get ready. I'm gonna be looking, J Love, for Tuesday because I want to see what happens. But again, as we say, laughing, but I will be looking. But as I say, definitely there's a time for change. There's a need for change, and we just want to shock the conscious to let people understand and know what some of the things that's going on, and know that and let them know that they can help assist in changing these things, even if nothing but coming to the courtroom and sitting in and saying what you have to say. We can come up with a lot of different ways to do some things. That the biggest thing and the first thing is educating the people. And I thank everybody on the panel for coming on the panel tonight and every night to educate the people, because we are the eyes and the ears and the voice for the people who are not aware of what's going on in the court system and the jail systems in the world, or whatever the case may be. So I appreciate everybody that takes their time out to make sure that the people get what we know and what our practical experiences, or whether it be through a loved one or actually through our experience, have experienced. So with that being said, I would look forward to seeing everyone again next Sunday at 8 p.m. And until then, everybody have a great night. Good night.
Good night.
Good night. Good night.
Bye.